I think you do need treatment, Mr. Lunsford, but also this offense carries a little punishment element to it. So my plan is to get the punishment out of the way first, and for us to engage in some sort of treatment plan.
Today's courtroom docket is packed with everything that makes real justice so unpredictable. Guilty pleas, prison time, treatment options, second chances, and judges trying to balance punishment with rehabilitation. Right out of the gate, we're watching Rachel Spencer face a theft charge where the court is already signaling maximum time may be on the table. But that's just the beginning. As this hearing unfolds, we'll also see defendants asking for mercy, judges breaking down community control, treatment programs, jail credit, restitution, and what happens when the court believes someone needs consequences first and help second. Pay close attention, because some defendants accept responsibility immediately, others try to explain themselves, and a few hearings turn on one big question. Is this person truly ready to change, or just trying to survive sentencing day?
It's the case of the state of Ohio versus Rachel Spencer, also known as Marston, case number 25 CR 43234. Present before the court is Ms. Spencer, right?
Yes, sir.
Represented by Mr. Clark, and we have Ms. Hyatt from the prosecutor's office. We are here today for pretrial, but it's my understanding that Ms. Spencer is going to be entering a plea of guilty to one count of theft. Is that accurately stated?
Yes, sir.
Yes, Your Honor.
Ms. Spencer, I know we've been through this a number of times before, but I want to make sure that we have a clean record in each one of our cases. How old are you?
I'm 32. I'll be 33 in April.
How far did you go in school?
I graduated.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, my plan is to sentence you to prison in the case. I think it makes sense for us to do a PSI and go ahead and get the referral for the community-based corrections facility out of the way. But if we want to go forward with sentence today, we can do that. But I think it might be better to make the referral. Officer Evans, I know this is not your case, and I don't want to put you on the spot, but we probably need that referral now, right? If we're going to refer somebody to a CBCF following judicial release? Or can we do it?
I've seen it both ways. We can also do it as if she's in prison. We can do that at a conference.
Oh, okay.
Judge, if I may, I just wanted to kind of give you an update. From what I'm hearing from my client, I think she's just agreeable to do the 12 months.
Oh, she just wants to serve it out?
CBCF,
Yes.
yeah, just
Oh,
serve
okay.
out the time and
Yes.
be done.
Yes,
All right,
sir.
that does simplify things to some certain degree. So, Ms. Marston, other than what I just told you, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Mr. Clark before you signed it?
Yes, I did.
Are you satisfied with the representation that you've received in the case?
Yes, I am.
You're going to enter a plea of guilty to one count of theft. It's a fifth-degree felony, punishable by up to 12 months in prison and a $2,500 fine. There's no mandatory prison in the case, but I do intend to send you to prison. You're also subject to an optional period of post-release control of up to 2 years, but you might be also eligible for things like transitional control, early release. They don't send me a letter anymore and ask me permission, but if they did, I don't see any reason not to do that.
Okay.
But I'm going to sentence you to the maximum penalty in the case. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to this prison sentence. Is that what you want to do?
That's what I want to do.
Ms. Hyatt, what are the facts?
Your Honor, if this case had proceeded to trial, the state would have shown beyond a reasonable doubt that between the dates of September 5th through the 7th of 2025, while this defendant, Rachel Spencer, aka Marston, was at the Ameristop in Lebanon, Warren County, Ohio, she did with purpose to deprive the owner of Ameristop of property. In this case, it was money that she and her husband, who wrote on checks that allegedly belonged to their business, Spencer's Landscaping, the co-defendant has already admitted that he wrote these checks knowing that they would be dishonored, but she then went and cashed two of the checks at this location, knowing and obtained the money by this deception. This is a felony of the fifth degree due to the fact that the amount is over $1,000.
Anything on those facts, Mr. Byrne?
Nothing on the facts, Your Honor.
Ms. Spencer, did you hear those facts?
Yes,
Do you admit they are true?
yes,
You understand the rights you're giving up by entering a plea?
yes,
What's your plea?
guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go forward with sentence today?
No, Your Honor.
She has 0 days of jail time credit on this case because she's been serving cases for other courts, right?
For Lebanon Court, yes, Your Honor.
And restitution is $10,650.
Correct. Joint and several with her husband.
Anything else from the state?
No, that would be it.
Mr. Clark?
Nothing further, Your Honor.
Anything you want to tell me, Ms. Spencer? All right, court is going to impose a 12-month prison sentence. This includes the optional period of post-release control. That means the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. It's automatically consecutive to the time that you would receive for that new felony. I'm not going to impose a fine. I am going to impose the cost plus the restitution, the amount of $10,650, which will be joint and severable with Dalton Spencer. Anything else we need to do today?
No, Your Honor, thank you.
Don't
All right,
believe so,
finally,
Your
Ms. Spencer, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. If you want judicial release into a CBCF after 6 months, if you change your mind, send me a letter, we'll see what we can do.
I will, thank you.
All right, that's all.
Thank you.
This is the case of the state of Ohio versus Dax Durham. This is case number 25 CR 43136. Present before the court is Mr. Durham, represented by Mr. Kirby. We have Mr. View from the prosecutor's office, Officer Evans from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, Judge.
91 days of jail time credit, no restitution. Sound right to everybody?
Yes.
Mr. View from the state?
Nothing additional from the state judge. Thank you.
Officer Evans?
Nothing further, Your Honor.
Mr. Kirby?
Judge, Mr. Durham is from Kentucky. He lives there with his wife. She's a nurse practitioner. He has an excellent support system. After his most recent stint in prison, he did demonstrate a significant time in recovery and sober. Your Honor, he's taken responsibility for his actions. While incarcerated here in the county jail, he has participated in the kitchen. Judge, he has been compliant with the pre-sentence investigation. Would ask the court to keep his jail time local and as minimal as possible, make him eligible for the litter pickup program. He does have a pending case in Kentucky to which he has a trial that he is going to set it out for. He just wants to put this behind him, move on from this, and that's all, Judge.
Does he have a holder from Kentucky? Do we know?
Not to my knowledge. He
Okay.
relays to me that he had a trial date at some point. I don't know much more beyond that.
Mr. Durham, anything that you want to tell me?
No, sir.
All right, court's going to sentence you to 180 days in jail. I'm going to credit you the 91 days that you have already done. I find that you're indigent for the purposes of fines and costs. There will be no financial sanction. Technically, you're on community control while you're in the jail. So if you got caught with drugs or got in a fight, I could still send you to prison for up to the maximum penalty, which is 12 months in prison. But the plan is just to serve out the remainder of your time and get on to Kentucky. We do have the issue of litter. I'll make you eligible for the litter. If you have a holder from Kentucky, though, you won't be able to go out, but you can still get good days credit for time that you work in the kitchen, even if you can't get out on litter. If you do go out on litter, you'll get an extra day of jail time credit for every day that you go out on the pickup crew. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. Good luck to you, Mr. Durham.
Thank you, Judge.
Try to call Monday. This is the case of the state of Ohio versus Amber George, case number 25 CR 43243. Present before the court is Ms. George, appearing remotely. Can you hear me, Ms. George?
Yes, sir.
All right, and we have in court today her attorney, Jesse Clark, and we have Mr. View from the prosecutor's office and Officer Evans from probation. Mr. Clark, have you already been assigned to this case? I don't remember if we did that.
Your
or
Honor,
not.
I've been assigned on a prior case of Miss George's.
Okay, well, we can clean up that paperwork later. All right, Ms. George, you are charged with 1 count of aggravated possession of drugs. It's a 5th-degree felony, punishable by up to 12 months in prison. We also have a paraphernalia case, which is a 4th-degree misdemeanor. The plan today is to enter a not guilty plea on your behalf, and I'm going to set this for a pretrial in about 30 days or so. And we anticipate that you will appear also remotely from Monday for the pretrial. My plan in this case is to continue doing what we're already doing in the case, but Mr. Clark has some work to do before we can figure out how we're going to move that case forward. Do you understand all of that?
Yes, sir.
Do you have any questions?
No, sir.
How's the Monday program going so far?
It is really awesome. I was just talking to Hillary about it. I got to phase last week. My clinician she's wonderful. She's kind of let me doctor my own treatment plan so that it helps me to work on the issues that I need to work on, such as healing with traumas and grief. I started my trauma class 2 weeks ago. My grief class starts in 3 weeks. I work in the kitchen now. I'm going to apply to be a peer mentor here in next week, actually. So it's going really good.
All right, I'm going to go ahead and enter a not guilty plea on your behalf. And you have received a copy of the indictment, right? We sent it to you?
Yes, sir.
All right, we waive the reading of the indictment and any defects associated with service?
Yes, Your Honor.
All right. So I'm going to grant you an OR bond in this case. That doesn't mean that you get out, Ms. George, because we're still holding you on the other case. And we're going to set it for a Zoom pretrial. Mr. Clark, I don't care if you want to appear by Zoom also. That part doesn't matter to me. Sometimes it's easier, though, if you're here.
Got it.
And we'll set it in about 30 days. Anything else for today?
No, Your Honor.
Don't believe so.
All right, we'll see everybody back in about 30 days. Thank you, Ms. George.
Real quick before we go, Jesse, can I have your number?
I was just gonna ask you if you still have my business card, but I think that answers the question. Yeah. Yep, I can do that.
Go ahead. Go ahead.
You ready?
Yep.
937-748-2522.
Okay, thank you.
Thank you.
Have a good day, Hillary.
Bye, everyone.
This is the case of the State of Ohio versus Justin Lunsford, case number 25 CR 43048. Present before the court is Mr. Lunsford, right?
Yes, sir.
Represented by Mr. Brenner. We have Mr. View from the prosecutor's office, Officer Torek from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor. Yes, Judge.
Any reason not to go forward with the sentence today?
No. No, Your Honor.
As a preliminary matter, Mr. Lunsford is on the felony of the 1st degree subject to an indefinite term. Mr. Lunsford, that means that you're going to receive both a minimum and a maximum term. I have given your attorney something called notifications of indefinite term. We call this a Reagan-Tokes sentence. I can read this to you, or if you're satisfied that you've been notified and understand Reagan-Tokes, we can just go on.
I'm satisfied.
All right, I'll attach the notification to the sentencing entry as Exhibit 1. We also have post-release control. You're going to be subject to a mandatory post-release control period of anywhere from 2 to 5 years. Do you want me to read this to you, or are you satisfied that you've been notified and understand post-release control?
I'm satisfied.
All right, we have 130 days of jail time credit. Anything else? Preliminary before we get started.
No, Your Honor.
All right, Mr. View, on behalf of the state.
Your Honor, just for the record, the state has been in contact with Deputy Fox, the victim of count 1, in terms of his input for the case. He did not have a specific recommendation on but he did believe that based upon the circumstances of the case and the seriousness of the offense, that a prison sentence is warranted. He was notified of today's hearing, and he was not intending to appear today. In terms of the state's recommendation for the case, Your Honor, pursuant to our plea agreement, the state's recommendation as to count one is a minimum definite term of 4 years to a maximum indefinite term of 6 years. As required by statute for count two, the consecutive sentence is required under the statute under 2921 331D. We would recommend a 24-month consecutive term, and as to count three, a concurrent term of 12 months, and as to count four, 180 days concurrent as required by statute. There is a $715 mandatory fine that cannot be waived. We had some discussions in chambers as to whether or not the sentence to count one is mandatory. I do not believe that it is. He has not been previously convicted. He's been charged previously with felonies of the second degree, but was not convicted of those, so I don't believe that that is a mandatory term. In terms of the state's recommendation, there is a Class 2 license suspension under the failure to comply. Given the defendant's prior history of OVIs and the seriousness of these offenses, the state's recommendation is a 10-year license suspension on the case as well.
Officer Tork, anything from probation?
Nothing further.
Mr. Brenner?
Your Honor, thank you, Your Honor. I know we've had some conversations back in chambers, and I want to say on Mr. Lunsford's behalf, when I reviewed the evidence and watched the video with him, the first thing that he said to me was that he barely remembered what happened. Prior to this incident, he had been in a sober living facility. He's been struggling with meth use for quite some time. I think that goes along with some mental health issues he's also been struggling with. He's anxious to get some kind of treatment in order, and he understands that he has a lengthy criminal history, that he obviously made a huge mistake on this case, and that he would like the opportunity to receive both mental health and drug and alcohol treatment. I know that he did the substance abuse program over at the jail. He completed that in the time that he's there. He's talked to me just while we've been sitting here about programs that he'd like to do while in the custody of the DRC. And so, Your Honor, we understand that given the seriousness of the offenses, given his guilty plea, that a prison term is going to come down the pike. We just ask that it be on the shorter end and that he be permitted to apply for judicial release. Obviously, that's going to be contingent on good behavior and on his progress in the facility, but that he be made eligible for judicial release as soon as practicable, Your Honor, and as soon as the court will be willing to entertain that. Because again, I think Mr. Lunsford, which is not terribly uncommon to see in this court, I think he'll be the first to acknowledge that he's getting too old for this, that he's lived his life in a way that has led him to this point, and that he wants to get better and he wants to become a productive member of society. That's going to take some work, and there's going to be some punishment as part of that. But we just ask the court to take that into consideration and, again, give him the opportunity in a couple of years to apply for judicial and hopefully complete some more programming, and so he can land on his feet when he's all said and done. Thank you.
Mr. Lunsford, is there anything that you would like to tell me?
No, sir. You about summed it up. Thank you.
I think you do need treatment, Mr. Lunsford, but also this offense carries with a punishment element to it. So my plan is to get the punishment out of the way first and for us to engage in some sort of treatment plan. Yeah. That's kind of up to you, though, because it's on you to decide whether or not you're going to file for judicial release. I'm going to give you a 2 to 3 year prison sentence on the first-degree felony. That means that it's presumed that you're released at the minimum term. But the Department of Rehabilitation Corrections may, under certain circumstances, keep you up to that extra year if you don't behave yourself while you are in the institution. On the third-degree felony, I'm going to sentence you to 24 months. On the fifth-degree felony, I'm going to sentence you to 11 months. I'm going to order that these all be served consecutively because your criminal history demonstrates to me that a consecutive sentence is necessary to properly punish you. To protect the public, the overall sentence is not disproportionate to the conduct involved here or the danger posed by you. I'm going to give you a 180-day concurrent sentence on the misdemeanor, impose a fine in the amount of $715 plus the costs, and suspend your license for a period of 10 years. I will favorably consider granting you judicial release after a period of 3 years into a CBCF, But this was a serious offense, and a decent prison term is necessary for that. You do have the right to appeal this to the 12th District Court of Appeals in Middletown.
This is where the contrast in today's docket really starts hitting hard. Up to this point, we've already seen one defendant in Rachel Spencer basically accept that prison is coming and choose to serve it out, while Dax Durham gets a county jail sentence structured around time served, work eligibility, and keeping things local. But with Justin Lunsford, the stakes jump fast. The judge is dealing with a far more serious sentencing structure here, including an indefinite term, mandatory post-release control, consecutive prison time, a fine, and a long license suspension. And what stands out is that the judge isn't pretending treatment alone erases the seriousness of the offense. He's drawing a firm line. Punishment comes first, then maybe rehabilitation if the defendant proves he's serious later. That's a huge theme in criminal court. Accountability is not canceled just because addiction or mental health is part of the story. What do you think? When someone clearly needs treatment, should courts focus more on recovery, or does public safety have to come first no matter what?
If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they'll all be provided to you at no charge. Anything else we need to do? Anything I forgot?
No, Your Honor.
There.
Good luck to you, Mr. Lunsford.
Thank you, Your Honor. Be safe.
This year.
Hogan. Case number 25 CR 43006. Present before the court is Mr. Hogan, right?
Yes, sir.
Represented by Mr. Perry. We have Mr. Harris in the prosecutor's office, Officer Katz from probation. We're here today, Mr. Hogan, because your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes outpatient drug and alcohol treatment, and the court's thinking for a change program. You're going to follow the rules. You're going to refrain from the use of drugs or alcohol during the treatment period. If you do all of these things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes, sir.
How old are you?
61,
How far did you go in school?
GED,
Are you able to read and write English?
yes.
Are you under the influence of drugs or alcohol?
No,
Are you taking any medications?
yes.
What are you taking?
Suboxone,
Are you taking anything that would interfere with your ability to understand what we're doing here today?
no, sir.
Are you a United States citizen?
Yes,
I have a document entitled Change of Plea and Entry. Looks like on the second page is a signature above the line defendant. Is that your signature?
yes, Your Honor.
Did you review this with Mr. Perry before you signed it?
Yes, Your Honor.
Are you satisfied with the representation that you've received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to one count of attempted trespass into habitation. It's 5th degree felony, punishable by up to 12 months in prison and a $2,500 fine. There is a presumption that I would not send you to prison even if you don't successfully complete the ILC, but if I do have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights.
Yes,
You're
sir.
presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, Your Honor.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about August 20th of 2025, City of Lebanon, Warren County, Ohio, Curtis Hogan, by force, attempted to trespass in another's home by attempting to open the door and also removing a screen and attempting to open a window. Again, all occurring in the City of Lebanon, Warren County.
Anything on those facts, Mr. Perry?
No, sir.
Mr. Hogan, did you hear those facts?
Sorry.
Did you hear those facts?
I did.
Do you admit that they are true?
Yes, Your Honor.
Do you understand the rights you're giving up by entering a plea?
Yes, Your Honor.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan. I'm a little concerned, Mr. Hogan, that you haven't been as honest as and upfront as you should be in these assessments. The thing about ILC, Mr. Hogan, is number one, it's more work than being on probation, and two, it requires your participation and your honesty. If you want to be honest about all of this and get better, ILC is for you. If you don't want to be honest about this and are just looking for a minimum sort of sentence, ILC is not really for you. So we're going to get another assessment. You're going to enter into and successfully complete drug and alcohol treatment on an outpatient basis. You're going to complete my Thinking for a Change program. You're not to have any contact whatsoever with the victim in the case. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. And you're going to be subject to random drug testing. Anything else we need to do?
Your Honor, we would also recommend that he be placed on a TAD monitor due to his continuous alcohol use.
That makes sense. We'll put him on a TAD monitor for up to 60 days.
Judge, if the court could, at least at this moment, I don't think we should put any limits on the use of the TAD. Did you say 60 days? Would you prefer 60 days or longer
What's that?
on the alcohol?
How long should I wear it?
Yeah.
Longer.
So could we just maybe hold on that?
I'm fine leaving it open-ended, no more than 180 days, so,
Okay, I'll leave a note for Officer Nelson.
okay.
Great.
All right, so TAD for up to 180 days.
Thank you, Judge.
All right, good luck to you, Mr. Hogan.
Quick question for you. How long is county court holding you for?
We'll find out.
This is Earl Zanzinger Jr., 25 CR 42648. Present before the court is Mr. Zanzinger, right?
Yes.
Represented by Mr. Deary. We have Mr. Harrison, the prosecutor's office, Officer Martinez filling in from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, sir.
Is there any reason not to go forward with sentence today?
No, Your Honor.
We have 4 days of jail time credit, $592 in restitution, which may or may not have been paid, right?
We think we have documentation showing that, but yes, Your Honor.
All right, Mr. Harris, anything from the state?
Your Honor, one of the other issues in this case was the forfeiture of the vehicle. It's a 2020 Ford Edge. We asked that that be put on entry to show that it's forfeited to the lien holder or to the Springboro Police Department. Mr. Deary's provided me with some documentation just before we came out that indicates the vehicle was taken by the lien holder, potentially sold. So either way, we would like that on the entry to address that issue. I know there were some other issues as far as probation was concerned. The last time we were here for sentencing, the court gave some extra time to go and investigate that. Due to the weather, I think Ms. Sukavecki was unable to be here, so I understand the court wanted to go forward with sentencing at this time.
Officer Martinez, anything from probation?
Nothing in addition to what Officer Sukavecki had emailed you.
Mr. Deere?
Yeah, Honor, Mr. Zanzinger is 54 years old, 55 now. He was educated at Purdue. He's a business major and has spent his entire career in HR. He recently got a new job with a good company, a Fortune 500 company. He is engaged to this woman in the gallery, has 2 adult kids. Your Honor, Mr. Zanzinger well realizes and appreciates that he has had an alcohol problem that has gone on for too long. After this offense, he checked himself into a 30-day program called Lumiere. He successfully completed that. Then he went into outpatient at a place called Evergreen Counseling. He also has been going to AA at least twice a week, Your Honor. When he was at AA and in Evergreen, he heard about the MAD, Mothers Against Drunk Driving, OVI class, which he took. Your Honor, he has been on an alcohol monitor since this case started without incident. He has had his first grandbaby, and as I said, he is planning to get married. Your Honor, Mr. Zanzinger, he will tell you, is very remorseful. He understands the risk to which he put the community, and he took all the classes that I just described to make darn sure that this does not happen again. Thank you, Your Honor.
Mr. Zanzinger, what do you want to tell me?
First, I'd like to apologize for my behavior. It was inexcusable. It was something that I should have known better. And I'm deeply remorseful. I'm humiliated. I'm ashamed of myself. I worked very hard over the past 9 months to rectify the underlying issues that caused this in the first place. I'm dedicated to that program. I plan on furthering that with an LCD license, actually. I've been heavily involved with Lemire's alumni program. And through that process, I've discovered that I really want to do that as well, to help others who are suffering from a serious disease called alcoholism. And I want to help those that are in need and take what I've learned from my experience to do so. I am deeply ashamed of myself. I want the court all to know this. That is not who I am as a person. It's despicable, and I put people at risk, and I'm very ashamed of it. It should have never happened. I put people at risk. After that MAD program, I realized how dangerous and irresponsible my conduct was on that day. I take full responsibility. There's no one to blame for what I did other than myself. It's very shameful what I did. I have to walk around every day with that guilt on my shoulders. And it's something that I work on with my counseling group. I meet with them twice a week. I have a great support group that I never thought possible prior to this. I know I've had other incidents before, and I have built a support group that I have become lifelong friends with, who are dedicated to the same thing I am, is to remain sober and lead a healthy, productive, and prosperous life going forward. I have a grandson that means the world to me, and I do not want to be looked at like that. Some drunk person. I'm very ashamed and humiliated for what I did, and I don't know any other way to describe it. And I was wrong, and I had a problem, and I went and addressed the problem. I did everything I could, and I committed myself over these last 9 months to do just that, along with my future wife. We are engaged. There's a lot to look forward to, and I committed to this 100%, and I will continue to do so going forward. And it's not the person I want to be, and I want to show the world what I can be, and I have over the last some months, and that's what I want the court to know. I'm shaved. I am very humiliated for what I did, and it's wrong, and I should have known better. And that's all I have. Thank you.
So here's the thing, Mr. Zanzinger. There are 3 types of people on my docket that, in my experience, there is very little hope that they are not going to recidivate, means commit this offense again. And those 3 kinds of people are sex offenders, huffers, people who huff paint, and long-term alcoholics. Because what I know from my alcoholic base is they do great until they don't, and then they fall off a cliff, and then they get back into treatment. They're horrified, all of the things that you just said, which are all true. I believe that they're all true. The question is, you got to fight this every single day for the rest of your life, and you have to have this zeal every day, and it's tough. It's tough to maintain that level of commitment, but you got to figure out a way to do it. We're going to give you some tools on probation that are going to hopefully help you do that, but also we have some tools for punishment too, because there is incarceration that is called for in the case. I'm going to put you into my community control program on basic probation for a period of 3 years. I'm going to impose upon you the standard rules of supervision. You're not to be any bars, none of that kind of stuff. No alcohol in your residence. I'm going to order that you serve 64 days in the county jail, credit you the 4 days you have already done. Let you schedule your remaining 60 days sometime in the next 90 days. If you want to start it today, that's fine with me, doesn't matter. I'm going to continue you on the monitor until you are done with your jail days. When you start your jail days, we'll take the monitor off. I'm going to impose a fine in the amount of $1,350, order forfeiture of the motor vehicle, and $592 in restitution. Mr. Deary tells me that the restitution may have already been paid. If so, you get a credit for that, obviously, if it's been paid by your insurance. And whatever's going on with the vehicle. I order forfeiture, and it's up to the other people to implement that forfeiture. I'm going to suspend your license for a period of 6 years. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 18 months in prison. Anything else we need to do or anything that I forgot?
Cost, Your Honor.
Yes, costs will be assessed. All right, finally, Mr. Zenzinger, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. Good luck to you.
Your Honor, he is going to schedule. Should he talk to Hannah about that?
Yeah, he'll meet with somebody in probation today.
Should he walk around Hannah to probation? Okay. Thank you, Judge.
All right.
Thank you.
Is Mr. Monin here yet? Do we know? Okay. All right, well, yeah, let's go ahead and do that before we do McKenna. We're going to service the people who drove here before the people that are at home. Monin, case number 25 CR 43032. Present before the court is Mr. Monin, right?
Yes, sir.
Co-presented by Mr. Oswald. We have Mr. Harris from the prosecutor's office, Officer Niemeyer from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes.
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
No, Your Honor.
51 days of jail time credit, no restitution sound right to everybody?
Yes.
Correct.
All right, Mr. Harris, on behalf of the state.
Your Honor, I was just looking at the history on this. It looks like it was a fourth in time. Mandatory fine is affiliated with this, as well as the license suspension. I don't believe there was anything further regarding this case.
Officer Niemeyer, anything from probation?
Nothing further, Your Honor.
Mr. Oswald?
Your Honor, Mr. Monin's 33 years old. He did acknowledge his substance abuse problem in the pre-sentence investigation. Although he rated himself a 2, which may be a little low, he acknowledges there is an issue, and he also acknowledged he needs treatment. Telber House diagnosed him with severe cannabis use disorder, and they're recommending a level 1 outpatient services. So we're asking you to follow that recommendation and impose the mandatory minimums.
Anything you want to tell me, Mr. Monin?
Yes, sir. First off, I want to wish everyone safe travels on the way home. I want to apologize not only to the court but to the public of Ohio. Just it's been, whether it be marijuana or my own prescription pills, like it's not good to be driving under the influence at all of anything. And I've taken this time in jail to learn quite a bit. I actually been employed in the kitchen for quite a while. It's been my first ever boss, ever, and I didn't love myself before I came in here, sir. And just being in here, and I lead a Bible study every night, working out, and just taking every opportunity to build myself. Making best out of a negative situation. And I got my grandma out there. The reason she's not here because I thought they canceled court, and she's about to be 90, and I got her to take care of. I got a farm. I've got a lot of responsibilities, and you're not going to see me back in this courtroom, sir.
So here's the thing, Mr. Monin, and I get this a lot, so it's not a crack on you necessarily, but the people that tell me I've learned a lot since I've been in the jail, it does not work that way. And the jail does not give you any skills to stay sober. And when you leave the jail, whatever you learned in the jail, you usually leave behind in the jail. So you have some treatment in front of you that has to get done, and that is where you get the tools to think differently so that this kind of nonsense doesn't happen anymore. I'm going to put you into my community control program for a period of 3 years. I'm going to put you on basic probation and impose upon you the standard rules of probation. I'm going to order that you serve 60 days in the county jail, credit you the 51 days that you have already done. When you're done with the time in the county jail, you're going to enter into and successfully complete the Genesis program. Once you've completed the Genesis program, then I'm going to order that you be placed on 60 days of electronically monitored supervision with a curfew. I'm going to suspend your license for a period of 5 years and impose a fine in the amount of $1,540 plus the costs. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 30 months in prison. You know, do your jail, get out, do better, Mr. Monan. That's all, that's all we can do. All right, anything else? Anything I forgot?
No, you're, but on the suspension, how many years was that?
5 years.
Okay.
All right, finally, Mr. Monan, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. Good luck to you.
Thank you.
Your Honor, on that suspension, is it effective, is that today or back to the date?
Effective the date of the offense. All right, we're reset. This is the case of the State of Ohio versus Terry Newman, case number 25 CR 42874. Present before the court is the defendant, represented by Mr. Newberger. We have Mr. Harris from the prosecutor's office, Officer Niemeyer from probation. We are here today for sentencing. Everybody had the opportunity to review the PSI.
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
We have 15 days of jail time credit and no restitution. Is that right?
That's correct, Your Honor.
All right. Mr. Harris, on behalf of the state.
Your Honor, in review of the PSI, noted that he does have a history of alcohol and drug abuse. As we discussed in chambers, the facts of this case are concerning. I'm not sure he has a understanding of the gravity of the situation that was created. My understanding is that these issues would be addressed somewhat through probation. I would ask that there be a no contact order with Judy Ponder, that he not be within any area of her residence at this time, in hopes that somehow he would understand this might be new territory as far as the court's concerned. I haven't seen a history of this type of behavior. However, it is very concerning for the state.
Officer Niemeyer?
Nothing further, Your Honor.
Mr. Newberger?
I think Mr. Newman understands the gravity of this situation. I think he'll be an ideal candidate for community control. He also understands that whatever assessment, drug and alcohol assessment he gets, he will comply. This is his first felony conviction, and he's just turned 59 years old. Has no prior history similar to what these allegations are, and he understands he can't go back to the neighborhood or see the victim in this case, that there'll be a stay away. Oh, he asks that the EMD be.
Mr. Newman, what do you want to tell me?
Honestly, it's just the strangest situation I've ever been in. For 8 months, I would stop by her house. One day, I've been seeing a girl now for like the past 3 years, and she lives over on 123 in Lebanon. And she goes out and she picks at night, and she sells decent stuff online. So hanging out with her, I kind of figured out what she wanted and what she didn't want. And one day I was driving down the road and I seen a toy box at the end of the driveway, and I stopped in, and a lady came out and we started talking. I asked her if she was getting rid of it. And long story short, after then for about 8 months, I stopped by about once a month to see how she's doing. I brought in wood for her. I helped her mow her lawn. I've even vacuumed her house for her. Unfortunately, I did notice that when I was stopping by that she couldn't remember my name. So I figured, she's probably getting dementia and stuff like that. And the day that the incident happened, I actually was there before the incident supposedly happened. And I asked her, she asked me what I did for a living, and I told her I was a mechanic again. She asked me if I could check the fluids on her car. And I said I could, but I had something to do. It would be okay if I come back by. She said, fine. I said, well, I'm getting ready to take off. She even asked me, hey, could you hang out for a few more minutes? You're so easy to get along with, so easy to talk to. I said, yeah, sure. So I hung out for a few more minutes. Her neighbor stopped by just before I left and dropped some food off to her. And when he was dropping that off, I was getting up and I was getting ready to leave anyway. So I left and I came back, checked the fluids on her car. I knocked on her door like I always do. She opened the door for me, asked her for her keys. I went out, I started checking the fluids on her car. She came out, and I had her keys laying on the battery underneath the hood. And she picked her keys up, and I told her everything that was going on. And when I was done, I shut the hood and I followed her back inside. And then her neighbor came over and threw me out of the house. And so I left. I had no arguments, nothing. I just left, no big deal. And then the next day I was pulled over and found out that I had the warrant out for my arrest, which I had no clue what was even going on whatsoever. So, I mean, it kind of threw me for a loop. I meant no harm whatsoever to her at all. I'm not that type of person. Never have been. I'll help anybody in an instant. But now that this has happened, I've really reevaluated that. I've seen people that needs help, and it's made me gun shy. I won't help anybody anymore. It's got me to that point. I mean, I haven't been in trouble with the law in forever, ever. And this just slammed me, and I was like, wow. So yeah, it's really made me gun shy about helping anybody anymore. I've seen people broke down on the side of the road. I would stop. I got a pair of coveralls, and tools in my van. If I see somebody broke down before this, I would stop and help them out. I don't do it anymore. I'm afraid for my personal freedom because of what has happened, and it was all because of a dementia. And unfortunately, you can't control that, But I mean, I'm not a bad person. I've made mistakes. I've owned up to my mistakes in life. I don't run from my responsibilities. I took care of my mom for 13 years, and nobody else in the family did. And then when she passed away, everybody took their share out of the house and left me in the cold. So I've been homeless for 3.5 years now, trying to get myself out of a $14,000 debt. I was halfway out, and then this hit me. Now I'm back down. I was 7,000 in the hole, and now I'm back to 14,000 again in the hole. But I got a good job. I've been working there for 3 years now. My boss loves me, and I just want to put this all behind me and get on with my life.
I think that, Mr. Newman, you and I can agree that this is a bizarre set of circumstances.
Yes.
And, I don't really know what to make of it, to be honest with you. But, I mean, I know that you pled guilty to the charge in the case. So, for you to plead guilty and you expect me to treat you as if you're innocent is not really realistic on your part. Also, the folks in probation, somebody who maintains that they didn't do anything wrong is a bit of a mixed bag for them because, first of all, they want to make sure that this kind of stuff doesn't happen anymore and address those issues. So I don't really know where this is headed. But the other thing is, if you continue to be a law-abiding citizen and you don't give me any problems, you're probably going to successfully complete your probation. So it may not matter either way. I'm going to place you into my community control program for a period of 3 years on basic supervision. I'm going to impose upon you the standard rules of supervision. Whatever the Talbert assessment says you got to do. I'm also going to have you complete the Courts Thinking for a Change program. You're going to have no contact whatsoever with Ms. Ponder or the residence in which this occurred. Stay away from it altogether. I'm going to remove you from electronic monitoring today, give you credit for the 15 days of jail that you have already done. I'm not going to impose a fine. I am going to impose the costs upon you. If you violate the terms of your supervision, Mr. Newman, or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 18 months in prison. Anything else we need to do? Anything I forgot?
Was there
Color rights.
was there an order as far as for drug and alcohol outpatient?
Yeah, whatever the Talbert assessment is, that's what he needs to do.
Okay.
All right, finally, Mr. Newman, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge.
What makes this docket so compelling is that it shows how sentencing is almost never one size fits all. Rachel Spencer gets the full 12 months on the theft case along with restitution. Dax Durham receives a shorter county jail resolution built around time credit and compliance. Amber George's hearing goes in a very different direction, with the court keeping the case moving while recognizing her progress in treatment. Justin Lunsford faces the heaviest consequences here, with consecutive prison time, a fine, and a 10-year license suspension, a clear sign the court viewed punishment and public protection as top priorities. Curtis Hogan gets intervention in lieu of conviction, but only with strict honesty, treatment, and monitoring requirements. Earl Zanzinger and Mr. Mannon both receive structured community control tied to substance abuse conditions, jail time, fines, and long license suspensions. And Terry Newman's case may have been the most unusual of all, with the judge openly acknowledging how strange the facts sounded while still enforcing supervision, no contact orders, and compliance conditions. Across every hearing, the same message kept coming back. The court may offer opportunities, but responsibility still matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Good luck to you.
Thanks, sir.
Just, will he meet with you now?
I'll meet with somebody in probation today.
You know where to go.
Yeah. I got.
Good luck, Terry.
Thanks.